that mediation is not a lesser form of justice, but a wiser form of justice.
Thank you, sir. Taking out the valuable time of guiding the delegates here. Thank you very much. Now,
Controlled or owned by them are a party. Now let us understand the disputes where mediation is excluded. Section 6 of the Act, read with the first schedule, provides an indicative list of disputes or matters not fit for mediation. They are 1. Disputes against minors, deities, and persons with intellectual disabilities. 2. Constitutional criminal offences. 3. Any dispute relating to the levy, collection, penalties, direct or indirect tax refunds. 5. Complaints or proceedings initiated before any statutory authority or body in relation to registration, discipline, misconduct of any practitioner or other registered professionals. Disputes which have an effect on the rights of the third party who is not a party to the mediation proceedings, except in matrimonial disputes where the interest of the child is involved. Any investigation, inquiry, or proceeding before the Telecom Regulatory Authority of India, Telecom Dispute Settlement Commissions, Securities and Exchange Board of India, Securities Appellate Tribunal, and the Competition Act of 2002, land acquisition and determination of compensation under land acquisition clause or any provision of law providing for land acquisition. These are all the disputes which cannot be further mediation. Now let me focus on very few important and relevant sections of Mediation Act. Section 3(q) of the Act defines pre-litigation mediation as the process of undertaking mediation as provided under Section 5 for the settlement of disputes prior to filing of a suit or proceeding of a civil or commercial nature in respect thereof before a court or a notified tribunal under Section 2 of Section 5. Pre-litigation mediation is highly beneficial as it offers a proactive and cost-efficient means of settling conflicts before they evolve into formal, drawn-out legal battles. It promotes transparent communication, cooperation, and an adaptable approach to crafting solutions that align with the parties' requirements and concerns. This approach saves time, money, and resources while also preserving relationships and confidentiality. Overall, it enhances the efficiency and adaptability of the legal process. Now, I would want to refer to Section 8, which refers to accreditation and regulation of mediators. Section 8 to Section 12 of the Act provides for the qualifications and oversight of mediators. The Act allows the appointment of foreign nationals as mediators under specific conditions considering their qualifications, experience, and accreditation. Additionally, it accommodates the parties' preferences regarding the mediator's identity and appointment procedure. Furthermore, the new legislation effectively addresses the potential occurrence of conflicts of interest during mediation proceedings and establishes a well-defined procedure for the disclosure of any circumstances that may constitute a conflict of interest to manage such situations. Time period of Mediation Act 2023. As we all know, Section 18 of the Act provides that mediation proceedings must be completed within 120 days from the date of the first appearance or for an extended time frame of 180 days if agreed upon by the parties. Community mediation. Section 43 of the Mediation Act provides for a legal basis for community mediation to settle disputes affecting peace and harmony in the local areas. The Mediation Act 2023 has rendered a comprehensive and innovative legislative framework for an efficient and streamlined implementation of mediation in India. It has now introduced many features features which were given to the previous mediation frameworks, which are as follows. With the introduction of institutional mediation for resolution of disputes for commercial or otherwise, constantly offer essential administrative facilities and support for the mediation process. Its primary function would be to accredit mediators and to regulate mediation. The Act has expanded the statutory scope to recognize voluntary pre-litigation and online mediation. Section 5(1) of the Mediation Act stipulates that regardless of any mediation agreement, the involved parties have the option to voluntarily and by mutual consent resolve the dispute through mediation before initiating any civil or commercial lawsuit in any court, with the enforcement of domestic mediated settlement agreements and time-bound procedures. It would make the mediation process final and binding in nature. It can only be challenged on grounds of corruption, fraud, impersonation, or pertaining to disputes not fit for mediation. The provisions of this Act would have an overriding effect for enforcing mediation, irrespective of any inconsistent provisions present in extant clause or legally binding instruments. In Eshpal, Chaudhrani, and others versus State, the Supreme Court endorsed that the provisions of the Mediation Act can take precedence over conflicting provisions in other laws, particularly regarding compoundable criminal cases. Hence, the settlement shall be deemed enforceable and approved according to the stipulations outlined in the Civil Procedure Code of 1908, like a judicially issued judgment of the The mediation is very advantageous. It gives us many advantages. One, the parties have control over the mediation in terms of firstly, its scope. The terms of preference or issues can be limited or expanded during the course of proceedings. And secondly, its outcome, the right to decide whether to settle or not, and the terms of settlement. Two, mediation is participating. The parties get an opportunity to present their case in their own words and to directly participate in the negotiation. Three, mediation is voluntary and any party can opt out of it at any stage if he feels that it is not helping him. The self-determining nature of mediation ensures compliance with the settlement reached. Four, mediation procedure is speedy, efficient, and economical. Five, mediation procedure is simple and flexible. It can be modified to suit the demands of each case. Flexible scheduling allows parties to carry on with their day-to-day activities. 6. Mediation process is conducted in an informal, orderly, friendly, and conducive environment. 7. Mediation is a fair process. The mediator is impartial, neutral, and independent. The mediator ensures that pre-existing unequal relationships depending between the parties do not affect the negotiation. The mediation process is confidential. 9. The mediation process facilitates better and effective communication between the parties, which is crucial for a creative and meaningful negotiation. 10. Mediation helps to maintain, improve, restore relationships between the parties. Mediation always takes into account the long-term and underlying interests of parties in dispute resolution process, in examining alternatives, in generating and evaluating options, and finally, in settling the dispute with focus on the present and the future and not on the past. This provides an opportunity for parties to comprehensively resolve all their differences. In mediation, the focus is on resolving the dispute in a mutually beneficial settlement. Mediation settlement often leads to the settling of related collective risks between the parties as well. Mediation allows pre-litigating dispute resolution. Parties can accept creative, non-conventional remedies which satisfy their underlying and long-term interests. And the parties themselves sign the terms of settlement, satisfying their underlying needs, their underlying interests, there will be true compliance. Mediation promotes clarity. The disputes are put to rest fully and finally, as there is no scope for any appeal or revision and any further litigation. Refund of court fees is permitted as per rules in the case of settlement in a court-referred mediation. program for mediation cannot be effectively implemented unless and until there is adequate awareness among the consumer of justice. Thus, it is our bounden duty to create awareness among advocates, judges, and litigant public by using trained mediators so as to enable them to understand the intricacies of mediation. The role of parties, advocates, and mediators is vital in resolving the entire conflict between the parties through mediation. Thus, the solution lies not only in the hands of judges and justices, but in each and every citizen in order to achieve justice for all and by all. Mediation is not merely an alternative to education, but it is an institutional value in itself, one that reaffirms our collective faith in compassion, consensus, and the healing power of justice. Contemporary disputes are very simple. They cut across family and business, technology and community. Courts may provide legal answers, but the deeper currents of human conflict often remain unresolved. What people seek is not merely a verdict, but a pathway to move forward. Mediation offers this possibility, but it does more than resolve a case. It fosters solutions that endure. The value of mediation lies in three things. Firstly, empathy. Secondly, dignity. Thirdly, creativity. Its victory, its triumph is not just in achieving a settlement, but in resolving a dispute in a way that allows them, the way that allows the parties to settle a dispute, to continue having a relationship, whether personal or professional. Our founding father envisaged that provisions ought to be made for securing social justice in our constitution. Our preamble categorically says that endeavors must be made to secure justice, economic, social, and political to all people. I want to underscore the term social justice. It is through mediation that social justice is achieved. The Mediation Act 2023, while a crucial advancement in integrating mediation into the legal system, is not without criticisms. Section 28 of the Act permits challenges mediated agreements on specific grounds such as fraud, corruption, impersonation, or when mediation was conducted for disputes falling outside the scope of Section 6. These challenges must be initiated within 90 days of receiving the agreement, with a possible 90-day extension. However, these grounds for challenging the agreement are restricted and do not encompass issues like duress, coercion, or the discovery of fraud beyond the limitation period. Additionally, the Act does not allow non-signatories to challenge its presence in the realm of dispute resolution. By establishing clear standards, enhancing confidentiality, offering incentives, and ensuring enforceability, this legislation has substantially reshaped the mediation landscape. It promotes mediation as the primary avenue for resolving disputes, aiming to streamline legal procedures while fostering a culture of collaboration and cooperation among conflicting parties. The Act represents a significant stride towards a more efficient, effective, and harmonious approach to dispute resolution. In essence, the Mediation Act 2023 is a significant and progressive leap forward in the Indian legal landscape towards promoting efficient dispute resolution through mediation. While the Act provides for a structured law on mediation, the success will depend on its acceptability and adaptability to the Indian context. The other key shortcoming is that it forced law to be brought in consonance with the practices of international jurisdictions, which otherwise would have helped to integrate mediation seamlessly with global transactions. The Act increases institutional mediation, expands the scope to include voluntary pre-litigation and online mediation, and enforces domestic mediated settlement agreements. Yet critical gaps remain, particularly in the areas of lack of comprehensive accreditation by mediators, alignment with the Arbitration and Conciliation Act, and enforceability of cross-border mediation agreements. To address these shortcomings, firstly, the Act should facilitate the ability of parties to effectively enforce settlement agreements across various jurisdictions, simultaneously retaining the right to necessary checks and balances. Secondly, there is a need for uniform accreditation and independent regulation of mediators, incorporating international best practices and ensuring transparency and professionalism. Finally, amendments should be made to enhance clarity, particularly in distinguishing mediation from conciliation and providing guidelines for interim audit. Through these comprehensive reforms, the Mediation Act can utilize the potential of mediation in resolving disputes both domestically and on the international stage, thereby fostering a more efficient and equitable justice system. I conclude with the words of Abraham Lincoln. He once said, and I quote, "Discourage litigation, persuade your neighbors to compromise whenever you can point out to them how the long-term winner is often a real loser. A real loser in fees, a real loser in expenses, a real loser of time. Since time is wasted in litigation, and since time is very, very precious, I must acknowledge that mediation is still to reach the homes and the villages. We are still at the periphery. India, in one way, therefore, has put in more efforts for mediation to reach at homes and also the villages. Our goal must be to show every litigant, every citizen that mediation is not a lesser form of justice, but a wiser form of justice. I thank the organizers for giving me this opportunity. I thank Ravindra Vishwanath garu, Sri M.S. Ramchandra garu, and Maximum Murthy garu for giving me this opportunity. Thank you very much.